July, I would like to either highlight or add a couple items. First of all, I'm going to be recommending a policy that would be on the agenda for the legislative meeting at the end of the month. We've received a right-to-know request requesting a copy of the supervisor's packets that they review as part of preparing for this meeting and discussion and votes under the right-to-know law. And those packets are pre-deliberational packets that are exempt from the right-to-know requirement. The actual section, pull it up. Sarah, do you have it real quick?
Yep, it's section 708B10A and B.
There you go. So on the strength of that section, my position is those are not subject to right to know prior to the meeting, but that after the meeting and after votes and discussion occurs, they would become public records subject to exempt areas of the packet being removed. So my recommendation is we are not giving those out under my advice and counsel prior to the meeting under a right to know request. After the meeting, they will be turned over to my office. We will review, and their information such as the solicitor's report, that's absolutely attorney-client privilege, that's not discoverable under right to know. Anything that has to do with personnel, not discoverable. Any information from other attorneys, emails on litigation, that is not discoverable. So we need an opportunity to go through the packet to glean out anything that is not subject to right to know because of privilege, and then that packet, revised packet, will be made available prior to the next scheduled public meeting of the board. That's the procedure that I'm recommending you adopt as policy, and I'll word that for you for the next meeting. But that's to address a right to know request. We received more than one requesting the packet?
Several.
Yeah, so that's how we're gonna deal with it. I just wanna make a comment on the solicitor, or the attorney's fees. Yes, there is a $100,000 bill from Porter Wright. That's from legal services rendered January to the present. That bill is the result of all the Mader litigation, which we won every aspect of the case. So that isn't a lawsuit that the township pursued or initiated other than to protect its vested rights as a second-class township and the eminent domain code. You would hope that after there was a full hearing with testimony, ability to cross-examine, and the decision was rendered by Judge Emery, a highly respected judge, that it would end. But no, 3 separate appeals have been filed to her decision to the Commonwealth Court. We have to defend that. So the legal fees are going to continue, and that's no fault of the township. But that's what that $100,000 is. I want to make that clear for the public so that you know. As far as item number 10, there's a lot to this. There have been ongoing issues between the township and Peters Creek Sanitary Authority. There are a number of policy, operational, and administrative decisions that are being made that our members have disagreed with. And they have been vocal in voicing their disagreement. And I think it's consistent in the municipal realm that it's advisable to have a supervisor or two sit on municipal authority boards, because the understanding of development issues is best at the table where supervisors know exactly what is going on, what the needs of their particular township might be, and are better informed to represent the township at the authority level. It's my legal opinion, and it's Kathy Gallagher's legal opinion, that the Peters Creek Sanitary Authority Board cannot amend its bylaws to identify or restrict the type of individual that can be appointed to that board. That can only occur, and there's a section in the Municipal Authorities Act, if you really want to get into it, there's a section that deals with this very topic. And it's under amendment to the Articles of Incorporation. That's where all the major changes to the operation and government and functioning of an authority have to take place. And if they want to change it, they recommend an amendment to the Articles of Incorporation. And their amendment is they want to eliminate the ability of any supervisor or a relative of a supervisor from serving on the authority board. If they want to do that, they recommend that as an amendment to the articles. They send it to the governing municipalities that make up and created that board, that authority. In this case, it would be Peters, it would be Union, it would be Finleyville, and it would be Nottingham. Once again, the Municipal Authorities Act specifically says you decide if you're in favor of that amendment. That has not been done, okay? And so we're challenging the amendment to the bylaws that basically takes away multiple seats on that authority board, where these seats are, there's 3 of them, for this township to represent Union Township and the Peters Creek Joint Municipal Authority. There are other issues. I believe that an authority member is absolutely entitled to the documents, the contracts, the financial information of that authority board. Those members are responsible for the operations and government of the authority. They're the ones, these guys, that represent the township on that board, could be surcharged, not a secretary, not an authority manager. And not only are they entitled to that information, I think they're required to ask for that information in order to properly carry out their duties. Unfortunately, information that our board representatives asked for was not delivered to them, and they were told to file right-to-know requests. That would be tantamount to each supervisor here having to file a right-to-know request to get information regarding the governing of this township. That's absurd. That's not the case. That's not the law. There are other items. We very much would like to have a sewage service agreement. That's universal. Everybody has one. That's where you know how you're being handled by the authority, how your sewage rates are being determined, what is the mechanism for increasing the rates, what type of EDUs and taps are available to your particular watershed, what if there's a dispute, what about independent audit rights. That's what a sewage service agreement covers. The Act 37 plan for Peters Creek that deals with the watersheds that affect Union Township, that was adopted decades ago, in the Act 37 agreement provides that there'll be sewage service agreements with the servicing municipalities. That's not been done. And I think for the benefit of the residents and the developers in Union Township, you are entitled to that type of service agreement so that we know what's the relationship. We have gone one step further because of the significant housing development that's going to occur in this township, probably more so than any other participating municipality in the Peters Creek Authority. Excuse me. And because of the significant monies that we're being required to expend to provide sewage service in various parts of this township, the main one being under a consent order with the DEP, where they're threatening a fine of in excess of $250,000 if we don't go forward and deal with the sewage. It's not a matter of us going back and saying we couldn't get the money. That's not a defense to what the DEP is telling us. So I know that the feeling of this board is we have all of these new buildings going up. We have developers that are going to sign the check, put the sewer lines in. Everybody's going to become a sewer customer. We would like to own those service lines, to be able to charge a tap-in fee, to be able to charge a monthly reasonable service fee to maintain and replace the lines over the years, and to fray the cost of sewer projects throughout this township when you have 400 to 500 new residents coming in. I think that's competent government on the part of this board to take that position. We've been chastised for it. So, you can't leave Peters Creek Sanitary Authority. The Act 37 plan says that's where you gotta put your sewage in this part of the watershed. So it's not a matter of us creating our own authority, taking our sewage somewhere else. DEP won't let us. You have to deal with Peters Creek. You guys are married whether you like it or not. And for the benefit of future generations and how these issues are gonna be resolved, I think that the township has to take its stand right now to clarify these issues that have evolved into changing bylaws, filing a petition to remove a member because he's asked questions and therefore created a hostile work environment. I mean, it's all directed at Union Township. Union Township has to stand up for its position. And the bottom line is, you're doing this to protect the residents of Union Township. That's what number 10 is all about, okay? Open records, that law went into effect July 1. Governor signed it. It basically requires that all meeting agendas be made available for public inspection 24 hours before the public meeting. So this is a new law. Like I said, it went into effect July 1. We're going to be working through what we can do and what we can add, and are there exceptions if it's an emergency situation, but that was the reason, Bernie, that we said we couldn't put that on the agenda tonight, because we're still dealing with this new law that the governor just signed in. And it's designed to be more open, to let the public know what's going on in advance of the meeting, and not see the agenda for the first time when you walk in. It's now a law that we have to post that 24 hours before the meeting. And I've said enough, I'll jump in.
Very well said.